I've watched power shift quietly for decades. Usually it happens in boardrooms and committee hearings, not in front-page headlines. But once in a while, the country gets a cluster of decisions that effectively rewrite the rules of the game in real time. That's what just happened. The Supreme Court told Texas it can use a congressional map that critics say is racially biased, signaling to other states that aggressive partisan maps will get the benefit of the doubt. The court also agreed to hear Trump's challenge to automatic birthright citizenship, a doctrine most people assumed was settled for 150 years. And while we were all focused on the court, Congress pressed the Attorney General about the Epstein files as a judge in Florida moved to unseal old grand jury records. 3 different fronts, same underlying question: who really controls the rules in this country, and for whose benefit? Start with the map. Texas drew a new congressional map that, on paper, locks in Republican advantages even as the state's population becomes more diverse. A lower court looked at the lines, the demographics, and the voting patterns and concluded the map was likely racially discriminatory, that it diluted minority voting strength in violation of civil rights protections. In the past, that kind of finding often meant the map would be blocked or redrawn before an election. This time, the Supreme Court stepped in and told Texas it can use the map while the litigation continues. In practical terms, that means Republicans get to run the next election on a playing field shaped to their advantage, even if some parts of that field later get declared illegal. The signal here is more important than the technical reasoning. By allowing the map to stand, the court is telling state legislatures, especially those with one-party control, that unless you leave smoking gun evidence of racist intent, the justices are inclined to treat your drawings as political, not racial. Partisan gerrymandering, after all, has never been banned under the federal Constitution. The court has repeatedly said it isn't going to police maps just because they help one party. The fight has always been over when that line between hardball politics and racial discrimination gets crossed. When you presume lawmakers are acting in good faith, unless proof of bad faith is overwhelming, you move that line. Why does that matter beyond Texas? Because other Republican-led states are watching. If Texas can lock in a map that boosts one party and survives early challenges, similar states can do the same with more confidence. Analysts estimate that more aggressive maps in places like Texas, Florida, Georgia, and others could shift control of somewhere between 20 and 40 House seats over the coming cycles. That's not a small adjustment. That's the difference between fragile 2-seat majorities and stable governing coalitions. For investors and businesses, that means less policy whiplash in the House if one side locks in structural advantages, but it also means deeper frustration on the other side of the aisle, which can spill into everything from regulatory battles to street politics. At the same time, the court's willingness to privilege intent over effect dovetails with another case on its docket, a major challenge to parts of the Voting Rights Act. For years, civil rights plaintiffs have used that law to attack maps and rules that disproportionately hurt minority voters, even when direct evidence of discriminatory intent was hard to find. If the court extends the Texas logic, looking primarily at what lawmakers say they meant to do, and giving less weight to statistical disparities, the entire litigation landscape around elections changes. Lawsuits become harder to win, maps become more durable, and control of Congress starts to look less like a contest and more like a function of who dominated the last round of redistricting. Now layer on the second decision, birthright citizenship. The court has agreed to hear Trump's attempt to narrow who becomes a citizen automatically by being born on a soil. Most Americans grew up believing the 14th Amendment settled this forever. If you're born here, you're American, with rare exceptions like children of diplomats. Trump's executive order argues that this reading has been too broad, that the phrase subject to the jurisdiction in the amendment's text has teeth, and that children of people here illegally or on temporary visas don't meet that standard. The justices could have tossed this case aside. Critics called the order, obviously, unconstitutional. They pointed to a 1998 decision that recognized citizenship for a child born in San Francisco to Chinese immigrants. Instead, at least 4 justices voted to give the case full review. That doesn't mean Trump's position will win. It does mean the court thinks the question is serious enough to revisit at the highest level. Trump's lawyers argued that earlier precedents assumed the parents had some form of lawful permanent connection to the United States, a domicile in legal terms, and that extending automatic citizenship to children of transient or unlawful presence was never required by the text. Legal scholars are divided. Some say this is a radical reinterpretation. Others say it's a long overdue correction to an overly generous reading. Behind the legal arguments sits a demographic reality both parties understand. Estimates suggest tens of millions entered illegally in recent years, and many of them had children after arriving. Under the current interpretation, those children are citizens with full claims on schools, benefits, and eventually the ballot box, and can sponsor relatives over time. For Democrats, that trend has been baked into long-term electoral assumptions, a slowly changing electorate that leans more their way over time. For Republicans, it's been a source of anxiety and frustration, a sense that laws are being bent to favor those who broke the rules while legal immigrants wait years in line. If the court narrows birthright citizenship even modestly, it resets decades of political calculus and sends a clear message about how tightly the nation wants to define membership going forward. From an investor's perspective, both the redistricting ruling and the birthright case point in the same direction, a court comfortable making big structural calls, not just incremental tweaks. That kind of posture creates more uncertainty in the short run because past assumptions are suddenly open to revision, but it can create firmer ground later if new rules are clear. Elections, immigration, entitlement projections, housing demand, education spending, all of these long horizon variables depend on who lives where, who votes where, and under what rules. When the Supreme Court reopens foundational questions, analysts have to rewrite their long-term models. Some will resist. Others will see new opportunities in sectors linked to border security, election tech, and domestic labor markets. While all that is playing out at the top of the legal pyramid, another clock is ticking in the background, one tied to a scandal that has haunted the American elite for years, Jeffrey Epstein. Congress passed the so-called Epstein Files Transparency Act, requiring the Justice Department to release a large tranche of records within a fixed deadline. The law was backed by a rare bipartisan coalition, with lawmakers from both parties signing a letter to Attorney General Pam Bondi demanding a briefing on how, when, and how completely the department planned to comply. They want to know what has been reviewed, what still needs redactions, and whether the release will hit the statutory date. In other words, Congress isn't just passing a transparency law, it's following up to make sure it isn't quietly slow. At the same time, a federal judge in Florida has moved to unseal grand jury materials from an older Epstein case dating back around 2008-2009, when he received a widely criticized plea deal. Grand jury records are almost never open. Secrecy is supposed to be permanent, so witnesses can speak freely. The judge decided that the public interest, especially given how much is already known about Epstein and how central the case has become to public trust, now outweighs the normal presumption of secrecy. That means names, testimony, and investigatory details that have been hidden for nearly 2 decades may soon become available in some form, layered on top of whatever the Justice Department releases under the new law. Into this mix stepped Marjorie Taylor Greene. In a high-profile television interview, she described a phone call with Trump where he was reportedly angry that she backed a procedural move to force a vote on the transparency bill. According to her, he warned that releasing the files would hurt people. The press didn't wait for nuance. Within hours, headlines were implying guilt, cover-up, and self-protection. But context still matters. Trump ultimately did sign the transparency law. He could have tried to block it more aggressively. He didn't, and hurt people can mean many things in a case touching politicians, executives, foreign dignitaries, and victims who may not want every detail of their trauma made public. For years, if someone powerful wanted a scandal buried, they could count on a maze of sealed files, complex jurisdiction, and time. The Epstein saga is showing that those tools don't work as well anymore. Between transparency laws, FOIA requests, leaks, and digital archives, secrets have a shorter half-life. For the market, that doesn't just mean more embarrassment for a few names. It means a shift in the risk premium attached to reputational exposure. Corporate boards, universities, donors, and sponsors now have to assume that associations they thought were buried might resurface. Some will overreact, cutting ties at the first hint of controversy. Others will call for due process and context. But the overall trend is clear. The era of relying on sealed records to protect institutions is ending. When you put these 3 stories together, the map, the citizenship case, the Epstein files, a single through line emerges. American institutions are being forced to redefine core concepts under intense public scrutiny. Who counts as fairly represented? Who counts as a citizen? Who counts as trustworthy? Those are not small questions. The Supreme Court is being asked to move lines that have been in the same place for generations. Congress is flexing its oversight muscles on a Justice Department that would probably prefer to move slowly and quietly. And lower court judges are reopening doors that historically almost never budge. Is that chaos, or is that what a living constitutional system is supposed to look like? People who crave predictability will look at all this and see danger. The House map is shifting. The electorate itself may be defined differently if birthright citizenship is narrowed. Hidden files from a notorious case are about to hit the public conversation. But stagnation is its own kind of risk. A country that refuses to revisit old assumptions eventually finds itself governed by rules written for a world that no longer exists. The volume of illegal immigration, the intensity of polarization around redistricting, and the erosion of trust in elite circles are not the same as they were even 30 years ago. Institutions can either pretend nothing has changed or adapt noisily. For the 2026 midterms and beyond, the practical implications are enormous. If Republican-controlled states lean into the court's Texas signal, they will draw maps that lock in more seats, making the House more structurally favorable to them for years. That means investors can expect fewer sudden swings in fiscal and regulatory agendas, but also harder fights at the margins, where the losing side may resort to more aggressive tactics outside Congress. If the court trims birthright citizenship, immigration politics will shift from how many cross the border to what status do they and their children actually hold, altering debates over welfare burdens, labor supply, and long-term voter rolls. And as the Epstein files drip out, expect a rolling series of media frenzies, selective outrage, and reputational shocks that make elite networks even more cautious and insular. The temptation will be to see all of this as a crisis. It's a stress test. Courts, Congress, and agencies are being pushed to show whether they can apply old principles to new realities without either surrendering to mob emotion or hiding behind outdated comfort. Sometimes they'll fail. Sometimes they'll overreach. But the direction toward clearer rules on maps, a more explicit standard for citizenship, and more sunlight on past abuses is not inherently destructive. In markets, stress tests reveal which banks are fragile and which can handle shocks. In politics, moments like this reveal which institutions still believe in their mission and which only believed in their routines. So if you're watching all this and feeling overwhelmed, step back and ask 3 questions. First, what exactly did the court say? Not just what the headlines claim it implies. Second, what information is actually being released in the Epstein saga, and what is being speculated or insinuated without evidence. Third, how do these rulings and disclosures line up with the kind of country and markets you want in 10, 20, 30 years? Those are the questions serious people ask. Everyone else chases outrage because this week isn't really about Trump or Texas or even Epstein alone. It's about whether America is still capable of updating its rules through courts, laws, and transparency instead of through collapse. The fact that these fights are happening in the open, in written opinions and public letters and court orders, is a sign that the system is still trying to function. It's messy, it's loud. But in a constitutional republic, that's what adaptation looks like.